Fonseca-Cintron, docket number 2018-197. Representing the appellant, Onix Fonseca-Cintron, is Rebecca Turner. Seated at council table with Ms. Turner is Don Matthews. Representing the appellee, State of Vermont, is David Tartar.
Thank you. Counsel?
Good afternoon.
Good afternoon.
This is an appeal of the trial court's refusal to charge the jury self-defense, though there was overwhelming evidence to support it and defense counsel requested it. The charges at issue here are domestic assaults, and unlike other domestic assaults, presented a messy, complicated situation. He said, she said, of varying versions of what happened that day in June. And it was exactly this type of case where there was evidence that the complainant hit the Mr. Fonseca repeatedly, returned to his house repeatedly. The jury needed to hear that it was an option to consider self-defense in these charges.
So part of your claim or part of your appeal is that this was all one continuous act?
Yes, Your Honor.
Would you spell out how that works on these facts specifically?
Yes. So there were 4 times where the complainant went to Onix's house. It was the last time where the alleged domestic assaults occurred. It was the last time where 3 counts were asserted for domestic assault. 2 of the counts were charged as aggravated domestics and 1 a misdemeanor domestic. However, the actions constituting the 3 counts was one continuous affair where what was alleged started out in the bedroom and then went into the living room. So no significant break in time, no time to stop and reflect, to recommit to the commission of the assault.
So, but when he reached up and grabbed a sword off the wall once he got in the living room, that's kind of recommitting to the offense, isn't it?
Not under the analysis that this court has engaged in State v. Perillo and State v. Carrollton, and applying what has come to be known as the Fuller factors. Intervening time or intervening act sufficient to then constitute a separate chargeable offense requires reflection.
Actually, it's a slightly narrower holding, isn't it? In the cases that you just cited, those were all cases in which somebody was charged under the same statutory section for multiple acts, and the question was whether they were really one and the same act. Courts sometimes call those unit of prosecution cases. Isn't this really a Blockberger case because there were 3 separate charges, and so even if they had in fact been the same act, we would have to evaluate whether you could sustain those charges by looking at whether there's something unique about each of those charges that's not present in the other.
It is a double jeopardy violation for sure, but the Blockberger analysis, where we simply look at the elements and compare one to the other and whether they differ, and the analysis doesn't apply here because this is a question about how this court has defined the underlying conduct, battery, which has been defined and has been defined by this court through common law, through a course of its decisions, a continuous offense.
But you've got a battery with a deadly weapon as one, yes. Right? And then you have a battery that doesn't require a deadly weapon. Are those, let's say you had the same, I punched you and I hit you with a knife. Those couldn't be charged as 2 separate things, even if it was immediately thereafter?
That's right, Your Honor. This is what this case presents. Certainly the legislature was free to identify aggravating factors. In this specific case, use of a deadly weapon, and that is the extra element that the legislature identified as the aggravating factor, and they have decided to punish those types of battery offenses with the aggravating factor differently, and that's certainly fair. However, where the legislature is adopting what has been defined through common law, through this court's precedent, as a battery-like offense, certainly the government doesn't dispute that the charges here fall within that category. This court has defined this. this type of offense is a continuous assault. This court, in this instance, has established that the government is limited from prosecuting blow by blow, that results in egregious over-prosecution and multiplicity prohibited by the double jeopardy.
Assuming you're right, what's the remedy?
The remedy is, I think we can follow what the court has done in other cases where it has determined a double jeopardy violation, dismissal of the two, so there's only one count.
And is that
Remand
at
for
the,
resentencing.
Remand for new sentencing,
is
yes.
that at the
Thank you.
state's election as to which one stands?
This court has deferred to the state as a nod to the discretion inherent in the prosecutorial initiation of the charge. I would argue that this court has the authority to choose the dismissal and choose the lesser, because he has been subjected to unlawful multiplicitous charges, has gone through a jury trial, is sitting in jail. And I think in this instance, where he has been aggrieved on plain error grounds from double jeopardy, this court should exercise its discretion in the interest of justice and dismiss the greater two and return the misdemeanor. That this court has the inherent discretion to do this is recognized, I think, through the State v. Villar decision. And so I would encourage the court to go there. If there are no other questions about self-defense or any other issues, I'll reserve the remainder of my time.
Would you address the self-defense issue for us, at least briefly?
Certainly. The issue here is that there was overwhelming evidence of self-defense. The photographic evidence certainly showed that Onix was more severely injured than the complainant herself. The testimony by the complainant showed, and she admitted to hitting him. The last encounter, so it is confusing. There are lots of fighting and pushing by both sides coming in through the evidence. The police being called.
Who has the burden on the self-defense issue?
The burden has to be, there has to be a prima facie case of it.
So there's no burden of proof? The defendant has no burden of proof?
The defendant doesn't have an independent burden of proof to present its own evidence of it. If the evidence shows, then it is the defendant or the proponent who seeks to have the self-defense given to the jury to make the argument that the prima facie case is made, and that was done here. Defense counsel argued and showed, and the court acknowledged it was a closed case and only held back from giving the charge because it determined erroneously, relying on this court's decision, State v. Buckley, that because Onix testified, denying the actual specific acts of using the machete and strangulation, the hair pulling, those specific acts, just because he testified against it, he was precluded from that defense.
Didn't the court also note that, which the court is supposed to look at, that there wasn't sufficient evidence in the record to justify a self-defense instruction to the jury? It wasn't just that he denied the charges, it was that there wasn't sufficient evidence in the record to support the instruction. Didn't the court say that?
I think I read the court's reasoning for rejecting the self-defense as being based on the fact that the judge felt it was inconsistent inherently with the defendant's testimony. The argument presented in the briefing, of course, is that's not a valid reason.
But there's got to be some, it may not be valid reason if it's inconsistent with the defendant's testimony, but the struggle is there's got to be some evidence to support a prima facie case, which would include evidence not only of an objective basis for him to believe he was threatened or under threat of imminent bodily harm, but I gather there have to be some evidence that he actually believed that he was under threat of imminent bodily harm and that that's what motivated his actions. Is that not an element of the self-defense?
I do not think there is a subjective intent element, as the government asserts and as I argue back in the reply, that it is not supported, that this court's case law has long recognized it's a purely objective standard. It's a reasonable standard.
Well, it's a reasonable standard to evaluate whether the belief was reasonable, but you still have to have a belief, don't you? You don't get to invoke self-defense if you didn't actually think you needed to strike that blow in order to defend yourself.
Yes, there has to be reasonable belief that he would have felt so threatened. His reasonable belief was strongly supported by circumstantial evidence that he would have had that belief because of the blows to his head, his eye was bludgeoned. She testifies that she would have killed him had she had a tool and instrument to do so at that moment. The photos show it. We have a video capturing her aggressive, forceful fighting where he can't stand up to her. She's literally pushing him down. These are just moments before. This is circumstantial evidence to prove his reasonable belief. Ultimately, there is no inconsistency here. It is not inconsistent with the ultimate plea of not guilty. And to deny the defendant self-defense claim in this case would ultimately lower the burden on the state.
Let me ask a question. I'm going to change the paradigm a little bit. Let's assume that there is the circumstantial evidence sufficient to justify the self-defense charge, but the defendant says at trial, I don't want it. Under your theory, it sounds like the judge should give it anyway.
If the question is, can a defendant waive explicitly self-defense? Certainly. And I think that would be fair. But where the evidence is presented and where the defense counsel asks for it, then it should be given. I'd like to reserve the remainder of my time.
Thank you, counsel.
Good afternoon.
Good afternoon.
So I'd like to start by making one point about self-defense, and that is that the jury found beyond a reasonable doubt that the defendant pulled Jolene's hair in the kitchen, that he choked her in the bedroom, and that he beat her with the sheathed machete in the hallway. A successful self-defense claim would have to be that he did those things in his own self-defense. If instead he's saying, she was hitting me and I hit her back, that's not self-defense. That's saying what she says didn't happen, something else happened, and what that other thing was self-defense. But that's not a self-defense claim, that's a claim of innocence. So,
But we've done that, and I'm just thinking about other contexts. I'm thinking about, I think it was Pulaski, where the defendant's theory, I think in that case, was self-defense, but the evidence supported this other mitigating
Yes.
instruction. And we said it doesn't matter that it's not consistent with defendant's theory of the case or even testimony about what happened. It's supported by the overall evidence and inferences that we can draw. Why isn't this the same thing?
so the distinctions here are, first of all, he testified and he gave a version of events. And in that version of events, he's not saying, yes, I did those things, but I did them in self-defense. He's saying something else entirely happened. And so that is not a self-defense claim, that is a claim of innocence. So, and also, the case that I had thought about was in Ray Sharo, which it's come up in the context of the manslaughter, voluntary manslaughter, in which this court has said, well, we don't need to believe, we don't need to take everything a witness says is true. We can pick some of what she says, some of what he says, maybe mix in some inferences, and if there's enough there, then we're going to find there should have been an instruction on voluntary manslaughter. The distinction here is that in voluntary manslaughter, the state has the burden of proof beyond a reasonable doubt of the absence of provocation. Whereas here, it's the defense who has the burden of showing that he's entitled to it. And secondly, the facts are different in Sharo, because in Sharo, there was evidence, testimony of what was described as a violent struggle with the victim. And here, the defendant's testimony wasn't like that. All he testified was fending her off or trying to push her away from him. So both factually and legally, I think that those are distinctions. Now, I'd also like to turn to, the point I've just tried to make is that he didn't really make a self-defense claim. He made a claim, I did something else entirely, and that was in self-defense. That's not a self-defense claim, that's a claim of innocence. But even if we could understand it as a true self-defense claim, he's got to show the four elements. Now, I think he did make some of the elements, because he did testify, and if we have to assume the truth of his testimony in determining whether there's sufficient evidence for the instruction. And so doing that, yes, the jury could find that he was not the aggressor. That's the first element. But they also have to be able to find that he used a reasonable amount of force. How can we possibly find that when neither of them testified to anything that could be construed that way. He says, I use no force whatsoever. So you can't say, well, I'm gonna believe him a little bit, or I'm gonna believe part of what he says. There's nothing that can't be reconciled with a claim that he used a reasonable amount of force.
We can look at her injuries, and, I mean, he didn't break her neck. We know what the charges were for. We could infer, based on what the testimony was that she was doing to him, that the level of force that he brought to bear was commensurate. I mean, can't we be drawing inferences here when we're trying to figure out what the record supports?
I think you can draw inferences, but certainly the inferences have to be based upon the evidence. And the evidence here we take from their testimony. Yes, the wounds are some evidence, but they're also consistent with her testimony and his testimony about the early encounter, which we actually see on the videotape. But then we also have the reasonably believe the use of reasonable force was necessary to avoid this danger. So we're going to draw an inference about his state of mind when she gives no evidence whatsoever to support that, and he himself gives no evidence whatsoever to support that, because he says, I didn't use any force, so obviously I didn't believe I had to use force to avoid that. So I'm not sure what you're drawing the inference from. And I'd also point out that if the court finds that self-defense was required here, then in any case where the complainant says he hit me, and he says, no, I didn't hit her, she hit me, then self-defense will be a required instruction. Because this case is no different than any of those, because there'll always be a way you can parse it. We'll believe a little bit of her, a little bit of him, we'll mix in an inference, and maybe the jury could come to a conclusion that she did hit him like he said, and, he could have, under the circumstances, had a reasonable belief of bodily injury.
Could you address the
Yes.
multiplicity of the charges, please?
So basically what the
One
defendant
big
is saying
fight,
that,
right?
I'm sorry?
One big fight,
Yeah,
and at one point, a machete came into the picture.
right, a sheathed machete,
A sheath.
fortunately.
Machete. See,
So basically, the defendant is saying, one beating, one charge. No matter what the circumstances, no matter what the charges are, no matter what the elements are, one beating, one charge. But the defendant doesn't cite a single case where the charges, this court has found only one charge was supported, where the different charges each had element the other didn't. The cases that she cites all involve the same charge. And in fact, one of those cases, Carrollton, specifically distinguishes other cases on the grounds that those concerned charges each of which involved an element the other did not.
So none of the other three is a lesser included of any of the others?
That is correct.
If they were, then we'd have to go to the next step and ask whether they're distinct enough acts to support both charges?
Well, if they're, I guess maybe I jumped a step ahead. If they're lesser included, if they're actual literal lesser included charges, then it's one or the other. It wouldn't matter whether there was a,
Right, I guess I meant conceptually the elements of,
Right.
there's no charge that's fully subsumed in
Right.
terms of its elements with the
That's
other,
right.
regardless of which acts they were
right.
based on.
One required recklessly causing bodily injury, none of the others did. One required attempting to cause serious bodily injury, none of the others did. One required being armed with a deadly weapon and threatening to use it, none of the others did.
okay, I get the armed with a deadly weapon.
Yes.
But the recklessly caused bodily injury, I've got the information in front of me, can't determine what specific acts supported that charge, and I can't distinguish what specific acts were relied on to show the aggravated domestic.
So as it was charged and argued in the trial, the recklessly causing bodily injury was pulling her hair in the kitchen, and the attempt to cause serious bodily injury was choking her in the bedroom. And she gave quite graphic and distinct testimony about each.
Okay, but if I'm in a fist fight
Yes,
and I'm kicking and punching and biting,
yes.
is that 3 different acts?
It depends how they're charged. It depends what the
Exactly.
elements of each are. It depends what the elements of each are. So let me go back to something a little more basic. It's well-established decisions of this court, the U.S. Supreme Court, that how many charges you can bring based upon a single act is a legislative question. And how do we determine whether it's what the legislation has determined? This court and the U.S. Supreme Court has said, if each charge has an element the other does not, then we're going to presume that the legislature intended to allow the prosecutor to bring 2 charges. So then, and we've got that here. Then the next step, which this court has discussed, is now we have to take a closer look. And if there's a 100% overlap in the actual actions, in other words, if these 2 statutes sound like they each have a different element, but they're really just describing the same act different ways, then you can't charge them both. So the example of that would be, if I lie to a police officer, that could be described as giving a false statement to a police officer. It could be described as obstruction of justice, but there's no fact that one has to be proven to prove one and not to prove the other.
Was that Neisner?
Yes. So 100% factual overlap. So even if we have the statutes themselves, each requiring a different element, we still look at that, is there 100% factual overlap? Here, we pass that test as well. There's not 100% factual overlap because one required that he pull her hair and recklessly cause her bodily injury. Another required that he attempt to cause her serious bodily injury, and that was not by pulling her hair, but by choking her. And the third was threatening her with a deadly weapon while armed with one.
Well, take away the machete. You're in a tumultuous fight.
Yes,
You're biting, kicking, scratching,
yes,
pulling your hair,
yes.
wrestling. Is that because I've attacked various parts of the body during this fight? Is that give rise to different charges?
So if you're talking about the same statute, then I would say no. Like if it's causing bodily injury, for example, simple assault, causing bodily injury is one charge, the identical elements, then it's quite clear that we can't charge for each blow. That this court has said under the Fuller test, we have to look for some sort of separation in time and place and an opportunity for the defendant to recommit. That we need that. So you can't just charge 3 simple assaults for 3 punches.
Right.
Okay. So we don't have that situation here because we're not charging 3 simple assaults. Each count has an element the other does not, so we don't do that analysis. The analysis we do is we look at whether that one fact is actually being described 2 different ways, or whether in fact there's different things we have to prove for each of them. Now let's suppose I'm wrong on all of that. So then you would go to the Fuller test, and I would submit that even under the Fuller test we survive because the facts here are almost identical to Fuller. In Fuller we had assault, it was a sexual assault, happening in the bedroom. We had a victim who escaped and made it as far as the living room. We had a defendant who chased after the victim and assaulted again in the living room. And that was seen by this court as a recommitting to the offense. That's exactly what happened here, except that it was a physical, not a sexual assault. She was being choked in the bedroom. She broke away and made it into the hallway living room area. And then he began, and unlike Fuller, it was a different kind of assault. In Fuller, it was the same kind of thing. But here, first it was choking, and then, as one justice pointed out, he made a decision to lift the machete off the wall where it was on display. And so we have, even if I'm completely wrong about we're okay if each charge has an element the other does not, we still meet the Fuller test here. If there's no more questions, I will.
Okay, thank you very much. How about time?
The appellant has 4 minutes remaining.
Thank you.
I'll be quick, Your Honors. Lockberger doesn't control the multiplicity question here. This court's decisions defining battery does, Carrollton v. and Perillo. If this court applies Blockberger here and finds that the one element difference is the end-all to this argument, throws it out, what has the court done to the Fuller and Perillo and Carrollton line? The issue here is this is battery. The government argues that Neisner is 100% factually on point for FIPOs, on point for impeding a police officer. Here we have batteries, and this court has ruled repeatedly and clearly that in battery cases, it's a continuous offense. In continuous offense crimes, we look at whether or not the Fuller factors indicating not that there's just different movement, different actions, whether or not the different points within this continuum is significant enough that a defendant can be shown to recommit the intent. This is a felony offense. These are aggravated domestics. If the government is free to just charge different ways to charge an offense for assault, then it has done away with the Perillo and Carlton and just forced them to be more creative in their charging documents, to force them to do exactly this, to upcharge on aggravated, encourages them to charge the felonies and the misdemeanors. Thank you.
Thanks very much. Thank you.
Chief, Joe, we're going to take questions.
That concludes today's hearings.
What do you want to do?
Don't even ask me.